All rise in court. Good morning, everyone. Welcome to this court hearing. Today we'll be hearing a case between SARS and City Clothing regarding the 570,000 compensation payment that was made to an injured employee. The key issue is to whether the payment qualifies as a deductible expense under Section 11A of the Income Tax Act. We'll start with the opening sessions, starting with the SARS Commissioner.
Thank you. Honorable Judge and members of the court, today I stand as the Commissioner of South African Revenue Service, contesting the deduction of 570,000 claimed by City Clothing. Our argument is that this payment is not deductible under Section 11, subsection A, because it was not incurred in the production of income. It's allowed due to negligence and the failure to implement safety protocols, not from ordinary business operation. The expense is capital or personal in nature and lacks a direct connection to income generation. We will demonstrate through precedent and tax principle that this payment is not allowable as a deduction. I will rely on case law, including Port Elizabeth Electric Tramway Co. Ltd. and versus CI 1936 and Joe and Co. Pty Ltd. versus CI 1946. I will also refer to Section 23, subsection G, which disallows expenses not incurred for trade. This payment resulted from negligence, not from income-producing activities.
Honorable Judge, fellow attendants, I represent City Clothing, the respondent in this matter. We argue that the payment made to Mr. Zulu is deductible under Section 11, subsection A, because the injury occurred during employment on business premises. The expense is connected to the operation of our manufacturing process. It was incurred during trade and should therefore be deductible. We will reference the Port Elizabeth Electric Tramway Co. Limited versus CIR case to support our position. Our argument is also based on the principles from Jovi and CO and CIR versus Gin and Co. 1955, which support that the compensation paid due to injuries in the course of business is deductible. The payment was neither capital nor personal, it was operational. Thank you.
Your Honor, now we will hear their argument statements.
Honorable Judge, we refer to general deduction formula in Section 11, subsection A. Expenditure and losses actually incurred in production of income and not of a capital nature. This payment was triggered by employee injury, a result of not compliance with safety protocols. It is not closely linked to income-producing activities, but instead to the failure of occupational health standards. The link to income is too remote. In Joe and Co. Pty Ltd. versus CIR, the court ruled that compensation paid due to negligence is not deductible. Further, this is a once-off lump sum and not part of routine expenditure, thus leaning towards a capital nature. Therefore, SARS rightly disallow the deduction. Objection, my lord.
Judge, we argue that the injury occurred during the employee's performance of duties, clearly connected to income production. The expense is not capital because it does not result in the acquisition of an asset or enduring benefits. The payment is remedial, not punitive. We rely on Port Elizabeth Electric Tramway Co. Limited versus CIR, where the court stated expenses incurred in the course of a trade, even if due to accident or faulty, may be deductible if they are connected to the operations. This accident happened during normal trading activities, not outside of a trade. Thus, Section 11A, subsection A applies.
Now we have the visual presentation.
Thank you. Let us now hear the closing statements.
Your Honor, City Clothing's expenditure arose from preventable negligence. It was not directly related to income-producing activity, nor was it a cost of performing trade. Deductibility under Section 11A cannot be granted just because the payment relates to business, only if it's a necessary requiring cost of trade. I argue the court to disallow the deduction. The injury arose from unsafe practices, not ordinary business risk. The expense is not directly tied to income, not requiring or operational in nature, and is more compulsory and moral than commercial. In line with Joffrey and Greer West Estates Pty Ltd vs. CI, I argue the court to dismiss the taxpayer's claim.
Your Honor, we have shown this expense was incurred in the normal course of business and in response to a risk intrinsic to income production. The payment to Mr. Zulu is a deductible operational cost. I ask the court to consider case law precedent and the reality of factory operations and rule in our favor. We maintain the payment was incurred during trade, a cost of doing business in high-risk industry.
Objection, my lord. No.
You heard it, sir. Please continue.
A necessary step to maintain staff trust and productivity. We urge this court to allow the deduction under section 11, subsection A, in line with Port Elizabeth electrical law. Thank you.
Thank you. Observers, please assist me with your summary of the facts and recommendation.
The taxpayer has a strong link between the expense and their income producing activities. However, such makes a big point on which change which is in the
Yes.
My lord, I believe that City's Clothing's case is stronger if we consider payment as integration and also reputational management. But such were strong cultural limitations. People was inherently different because the payment was like whatever we does necessary.
Your Honor, if we put law on the table, the proceedings in jobs suggest similar facts. Injury during operations should only be paid or awarded to employees and not an outsider.
But, Your Honor, I recommend evaluating proportionality. Was the payment really compensatory to or was just partly punitive? The SARS argument is very strong on revenue versus capital decision, but really lacks focus on trade commission.
Wait. I wanted this to turn into a sentence. Otherwise, I will throw some of you observers outside. Please continue.
City Clothing's links between production and injury seems to be legitimate and tied to operations.
The lack of safety policy should not remove deductible because many losses come from the instead of
Your Honor, Joffrey may not fully apply. It involved a wrongful case then and legal liability, not business cost. City Clothing's payment was out of moral and practice business necessity.
The phrase in the production of income must be done practically, not ideally. The payment prevents legal consequences, which is ensuring uninterpreted operations. Could have City Clothing take insurance? Could they take capabilities?
But, my dear observer, such assumes that intention matters more than business necessity. This may be flawed. We should also consider that the injury occurred during the act of production, which seems key in this case.
If the court is negligent, the payment is a natural business outcome. Court must balance its interpretation and fairness with business reality.
After careful consideration, I conclude. The injury occurred during employment on business premises. The payment was connected to taxpayers' trade but was partly due to negligence. In line with Port Elizabeth Electrical Trainway, I agree. Then the portion of the 570,000 may be deductible as it relates to the income producing activity. The portion relates to the loss of income, for example, the 300,000 is allowable. While the balancing punitive compensation or negligence is disallowed. The matter is now concluded.